My esteemed Brother Justice Surikant, the eminent panelist, the stalwarts in the field, learned Attorney General, all Vice Chancellors, members of Bar Council of India, respected lawyers and law students, Brother Justice Surikant has very eruditely introduced the subject, and we'll be discussing henceforth. We have with us all the stalwarts, much sought after lawyers in the country. But nonetheless, the subject chosen for this session by the Bar Council of India, the changing landscape of criminal law, is one of the most burning topic and burning subject in the landscape of Indian jurisprudence, legal jurisprudence. The fine balancing between the needs of the victim, needs of the accused for a fair trial, and then the needs of the society and the needs of the state as a whole has to be so finely balanced that none of the stakeholders in these criminal trials should think that justice is not done to us. Much often, when we lean towards the liberty of the accused and other rights of a fair trial of an accused, there is a growing thinking amongst the victims and the society that they have been cornered in the whole system and zeal to do justice to the accused. And that is where our job becomes slightly difficult. And in these days when the law is changing, the method of committing crime is changing, the method of investigation is also changing. Every day we are faced with new challenges as to how to deal with those accused who are committing crime in a very, very, very sophisticated way. And the provisions of Evidence Act vis-a-vis the electronic evidence, those have to be discussed by all of us so that in the eventual analysis, the victory is of justice and not of an individual. The system has to overpower the individuals. We have to try hard to evolve a criminal justice system which is so finely balanced that the needs of all the sections of the society is taken care of. And we think with the robust criminal justice system this country has since time immemorial, as Honorable Justice Surikant has pointed out, we have all the resources, capacities and talents on all sides of society to deal with such a situation, and learned panelists would throw light on this. Thank you so much, and thank you Bar Council of India for organizing such a great international conference.
Thank you, Brother Prashant Mishra. As we understand, the landscape of criminal law is a state of perpetual transformation. So we will request Mr. R.S. Chima, Senior Advocate, whom I have seen for decades dealing with all kinds of criminal cases, and at a time when we didn't know even how to draft a bail application. We'll request him to enlighten us on this subject, and I will request the audience that be ready for your questions and your queries also, because eventually this is an interactive session. We would like to have the thought processing from your side as well.
Honorable Justice Surikant, Judge Supreme Court, Honorable Justice Prashant Kumar Mishra, Ji, Honorable Judge Supreme Court, the galaxy of my colleagues who humble me by their presence, the country's most distinguished law educationists, the Attorney General of India, who I hold in high respect, and my friends. I think we have very limited time, and I'll make a few key points. In the morning, my friend Amit Desai said, "You are working too much." So I thought I'll give a reply to him while you are all present. In 2011, we were both, besides other colleagues of ours, counsels in 2G. And I think Amit will recall, we persuaded the legendary Ram Jethmalani to conduct a cross-examination, and he conducted the cross-examination of PW7 Acharya ji with our assistance. And I think that was his last cross-examination. He was 84 at that time. So when he asked me, "You are working too much," I believe one change we must all make, me particularly, we should now work to pay back to the society. That is one lesson I take. Now, second question has always been elusive. What is our expectation from a criminal court and criminal law? As Honorable Justice Surikant said, a moral code. Everybody looking at it from his viewpoint. There's one story which has become apocryphal in my High Court, which I want to share with you, which raises the core question for me. The presiding judge was an ICS turned into judiciary, Justice Dullat, a brilliant judge. The arguments were heard in a division bench appeal. The death sentence was upheld. That, you know, at that time was the normal sentence. And while the judges were about to rise, a woman stood up, a rural woman. She wanted to speak. The staff tried to take her away. Justice Dullat said, "Let her say what she wants." Now, these sentences I have always carried in my mind. The lady said, "Motiyan waleo, insaf nahi hoya. Blessed judges, justice has not been done." But the reply which came continues to disturb me and should continue to disturb all of us. He said, "Bibi, ਅਸੀਂ ਕੌਣ ਹੈ ਇਨਸਾਫ ਕਰਨ ਵਾਲੇ? ਅਸੀਂ ਤਾਂ ਫੈਸਲੇ ਕਰਦੇ ਹਾਂ." Respectable lady, we are no one to decide. We only, to do justice, we only take decisions, we only decide. This was incidentally recalled by Mr. Dullat's son in his recent memoirs, but the point was missed. The point is, do we have a system which enables the judge, the lawyer, and all concerned to reach the truth, that the mismatch between the justice and the decision is, if not eliminated, at least minimized. And I'll only make a few short points because I want this to be an interactive session. I'm raising concerns. I'm saying our landscapes need to change. Supreme Court has been laying down the foundations, drawing the roadmap, but there are deep concerns which continue and which threaten to derail the entire system. I'll start with the areas. In the High Court where I usually practice, Punjab and Haryana, the division bench appeals are pending since 2003. That is a gap of 20 years. Imagine a man convicted somewhere in 1995 to 98, granted bail 10 years later, now going back if he's convicted, and the areas are mounting. I'm giving one example because not even 50 appeals are being heard in the course of an year. So one aspect to which I draw everybody's attention here, and I think probably we lawyers, the honorable judges, Bar Council most of all, has to see that we take steps to cut this down. The second concern, which we all very widely share, is the bail. Large scale detention of pre-trial prisoners is becoming the rule. And this detention is coming not because the judiciary is not following the dynamics of various judgments which came over the years, because statutes are being amended and introduced which take away the court's right to grant bail. These are twin conditions. These twin conditions are creating terribly anomalous situations. You have a man in 420 who's granted anticipatory bail in the scheduled or the main offense because it falls in section 41. He is rotting in jail in the ED matter in the same case. We have hundreds of chartered accountants today in jail, their bails having been denied because of the amended Indian Companies Act, section 212, which introduces serious fraud investigation office. And imagine the offenses are punishable up to 7 years, up to 10 years. And what pains me as a lawyer, as a citizen is, if we recall Gurbaksh Singh Sibia, it is the foundational judgment not on anticipatory bail which addresses, it is a foundational judgment on the right of bail itself. And their lordships start with examples of British India, a Calcutta judgment, Emperor versus Nagendra, and two Allahabad judgments, Emperor versus Hutchinson and Joglekar versus the Emperor. The last two judgments are Meerut conspiracy case. We were under a colonial regime. An imperialist power was running the show. And the sections were waging war against the state, 124A as well. And it is at that time the courts held the three cardinal principles, that an accused is assumed to be innocent till it's held otherwise, that an accused is in a much better position to defend himself when he's on bail, that bail is an integral part of a fair system, and bail, not jail, is the rule. Now, I would call upon all concerned here that we cannot countenance with the situation with which we are going and just see another part of it and then move on to the next issue. All these twin condition provisions say the notice of the bail shall be given to the Advocate General, to the public prosecutor. If the public prosecutor opposes the bail, then A, reasonable grounds to presume that he has committed the offense, and B, that he shall not commit any offense if released on bail. Both vague, both susceptible to negative interpretation. Now, nutshell kindly see, who has the authority to grant bail then, sir? It is the public prosecutor. If he doesn't oppose bail, then only can you get bail. So that is the second concern I think we carry. And I would even expect the Bar Council of India to come in a petition. The position in post-constitution independent India cannot be worse than the position of bail in a colonized country, which it was. We didn't have Article 21, we didn't have Article 14, So therefore, that is the second concern which I feel must bother all of us. The third is, as my lords noted, the sentencing part, the Juvenile Justice Act. Juvenile Justice Act was the one which went the farthest. Now we lawyers are also guilty here. Kindly read the judgments. I am speaking from the point of view of trial. Read the judgments today of the magisterial courts, read the judgments of the sessions courts in trial. You will be finding the judgment silent on the question of probation, be it the Probation of Offenders Act or Section 360 or 361. Completely. I remember when we joined practice in the late 70s, new CRPC had come. The final court had been commenting on, in Vishnu Day, court examined 361 CRPC and said that the requirement is he shall be entitled to probation unless there are circumstances to show that he is incapable of being redeeming or reform. The entire reform theory we have put at the back burners on considerations where we do not read our own law. I'll just passingly give one illustration. One of the offences under the old code is 304A. It's a rash and negligent act. It actually doesn't apply to driving only, but in practical cases it's only driving which is there. And we have judgments now saying no probation in 304A. And look at the irony. 304A does not require mens rea. So an individual case might have all kinds of ramifications. Therefore, on sentence, we need, and I would call upon the Bar Council of India to have workshops, to have projects, so that we facilitate the judiciary in this matter. We have changed very little. We are very sporadic. We are also very inconsistent in sentences. The other part. Now, on Juvenile Justice Act, we introduced some dynamic things which we have not been able to do. I'll just share some practical experiences. A juvenile has to be segregated from the other criminal. What we saw in Chandigarh is the juvenile was one. He couldn't be kept in Bodal jail. The poor fellow is in a solitary confinement in a one-room tenement. So we are doing the reverse of what should be done. Then the set of sentences which we need to introduce, which my lord referred to, community service, other methods, I think we have to harness the civil society. This entire exercise is a matter of execution. And the other 2 points I'll very briefly mention. Access to justice. We had the legal aid system. We have now introduced a very important system of enrolled defense lawyers. But I think we need very massive infusion of funds if we want equity, if we want to create a level playing field on this side of law. And since I started with public prosecutors, the last point I'll make is on public prosecutors. PMLA confers such big power on public prosecutor, I said. I was special public prosecutor, PMLA, for a few years in coal matters, appointed by the Apex Court. The Enforcement Directorate has no regular cadre of public prosecutors. Similarly, the Ministry of Corporate Affairs, which now operates this SFIO, does not have a regular cadre of public prosecutors. My mind immediately goes to USA, where a public prosecutor is a powerful, dynamic entity. And why he is relevant? One method of elimination of arrears in a changing society is plea bargaining. The USA public prosecutor is empowered very widely. So we need tall, highly salaried, highly qualified public prosecutors. So these are different areas we'll have to touch if we have to grapple with the situation and see that the landscape changes as it ought to be. With these words, I am thankful to the chair and all my friends.
Thank you, Mr. Chima. Really pointed out very the areas of grave concern for all and one, whether it's areas or the plight of bail, the sentencing, and of course the access to justice is something really, again, very important issue. And lastly about the public prosecutors, the method of their encadrement and the very high responsibility that lies on the shoulders of a public prosecutor. We'll request all of you to be ready to your responses, your viewpoint on these questions. We will very soon revert back to that. Meanwhile, I will request Mr. Ramakant Sharma, Senior Advocate, Chairman of the Bar Council of Bihar, to very briefly in a few minutes, maybe 5 minutes or 4 or 5 minutes, please just give your bullet points on the subject of the deliberations, and then we'll proceed on question answer issue.
Honorable Justice Suryakant Sahib, Honorable Mr. Justice Prashant Kumar Misra Sahib, a legal luminary, a legend, Chima Sahib, Desai Sahib, Luthra Sahib, known to everybody in India, Dayan Shankarji, sitting here. I can see most of my friends from Bihar State Bar Council of the dais, and our learned Attorney General, first row right hand side and left side the Vice Chancellor of ILUR. I am shaking in my shoes by seeing the legal luminaries here on a topic. Still, I am standing before all of you to share my views. Everybody part of this august evolving landscape of criminal justice. Ever evolving, I can say, criminal law in India, it is both an honor and a responsibility to address this topic. Over the years, India has evolved significant changes in the criminal justice system, driven by societal, technological, and legal developments. These changes have had far-reaching implications, both positive and challenging, and it is essential for us to understand and adapt to this evolving landscape. One of the most notable shifts in Indian criminal law has been the increasing emphasis of protecting the rights of accused. This change in the line with international human rights standards and the fundamental principles of justice. The introduction of safeguards such as the right to legal counsel, the right to remain silent, and the presumption of innocence until proven guilty has been instrumental in ensuring fair trials and preventing wrongful convictions. Historically, our legal system predominantly focused on the accused, often overlooking the rights and concerns of the victims. However, recent legislative changes, amendments and judicial decisions have recognized the importance of providing support and protection to victims. This includes measures such as victim compensation, legal aid, and counseling service to ensure a more compassionate and holistic approach to criminal justice. Ladies and gentlemen, furthermore, technology has played a pivotal role in the shaping the landscape of the criminal law. The advent of digital evidence such as emails, text messages, and social media interactions has revolutionized this way cases are investigated and prosecuted, it has also raised questions about the privacy and security of individuals, as well as the admissibility and authenticity of digital evidence in court. Another noteworthy development is the utilization of technology in criminal investigation and court proceedings. With the advent of digital forensic surveillance technologies and data analytics, law enforcement agencies now have powerful tools at their disposal to gather evidence and solve crimes. However, this has also raised concern about privacy and the potential for abuse, requiring a delicate balance between the enforcement needs and individuals' right. Moreover, the laws surrounding cyber crimes, cyber bullying have evolved to address the growing threat of online misconduct. India's Information Technology Act 2020 has been amended to include provisions for tackling cyber crimes, ensuring the individuals and businesses are protected in the digital realm. In recent years, there has been growing awareness and discussion about criminal justice reforms in India. The need for a speedier trial process has gained prominence, driven by realization that lengthy trials often result in delayed justice and overcrowded prisons. The introduction of alternative dispute resolution mechanism, plea bargaining, and the establishment of fast-track courts are some of the measures aimed at addressing this issue. Furthermore, the changing landscape of criminal law has also seen a shift towards decriminalization of certain offenses. Decriminalization of certain offenses. For instance, the Supreme Court historic verdict in 2018 decriminalized consensual homosexual relation, a significant step towards recognizing and protecting the rights of the LGBTQ community. This demonstrates the evolving social values and the judiciary commitment to aligning with them. The role of social media and the internet is shaping criminal law cannot be underestimated. Harassment, cyberbullying, and the dissemination of fake news have become pressing concern. As the result, laws related to cyber crimes and online offenses have been updated to address these emerging challenges, however, ensuring that those laws do not stifle freedom of speech and expression remains an ongoing challenge. While these developments are commendable, it is crucial to acknowledge the challenge that persists in the criminal justice system. The backlog of cases, slow judicial process, overcrowded prison continue to be pressing issues that need attention. Reforms are required to ensure timely and efficient justice delivery while upholding the principles of fairness and due process. Another significant change has been the growing awareness and activism around gender-based violence and the subsequent amendment to laws dealing with sexual offenses. The Nirbhaya case in 2012 served as a catalyst of legal reforms that have strengthened the legal framework for addressing sexual assault and harassment. These changes are steps in the right direction towards creating a safer and more equitable society. Additionally, the recent repeal of the Article 370 at Jammu and Kashmir has brought about a change in the jurisdiction and applicability of Indian criminal laws in that region, highlighting the dynamic nature of our legal system. The role of public awareness and legal education cannot be ignored. Vice Chancellor of our ILC is here. In the changing landscape of criminal law in India, it is imperative that citizens are aware of their rights and responsibilities with the legal framework. Legal literacy programs, seminars, and campaigns play a crucial role in fostering a better understanding of law and its implication. The changing landscape, the word used is very sensitive. The changing landscape of criminal law in India reflects our commitment to justice, human rights, and adapting to contemporary challenges. As criminal lawyers, we must continually educate ourselves and advocate for reforms that ensure a fair, efficient, and human criminal justice system. While waiting in the waiting room for honorable judges to come, I met the legendary Chima Sahib. this type of senior citizen who is determined that he has nothing to earn now, he has to serve the country, serve the nation, propose the things beneficial to the people. Something which we have deliberated in waiting room, a very alarming situation now you are talking of Juvenile Justice Act. When you say that bail will be granted to a juvenile, go and approach the court, Juvenile Justice Court. Why not anticipatory bail? Why you are keeping a juvenile in a confinement where you are keeping 200 criminals in a wards and secluded the juvenile in a single room? This must be changed. Now, while these changes are promising, it is essential to ensure that we uphold the principles of justice, fairness, human rights as we continue to evolve. Let us remain committed to building a criminal justice system that is both effective and just for all. I am missing if I don't discuss. Now, I was saying that proposed rewriting of the code, RPC, CRPC evidence, I don't even want to say because it is a proposed law. And better you people say that. But I say respectfully to this audience, this amendment, Indian criminal justice system for more than 160 years, the old system. It is said to be replaced by Bharatiya Nyaya Sanghita. The CRPC of 73 will be replaced by Bharatiya Nagarik Suraksha Sanghita, whereas the Indian Evidence Act will be replaced by Bharatiya Saksh Bill, as we all know. From 1860 up to till date, 2023, the country's criminal justice system functioned as the law but by British. With these three laws, there will be major change in criminal justice system in the country, as has been said by our Honorable Home Minister, Sri Amit Shah Sahib. Since we are in paucity of time, I cannot say more. About this rewriting of the codes, some certain comments came in Indian newspapers like Hindu and newspapers. But what is better in this reform, just I will conclude and take my seat. But the assertion that these bills are draconian compared to their previous actions lacks merit. This comment is not correct. Instead, the bills exhibit several modifications, including linguistic adjustment for gender inclusivity and replacement of outdated terms such as insanity with mental illness. There is also a measured configuration in the punitive degree for minor and serious offences. Significantly, the integration of ICT application with the criminal justice process is noteworthy. Although the scope is limited, innovations such as trial is essential, and the introduction of community service of India decision, notably the offence of sedition, has been judicially tempered to prevent misuse, facilitated by introducing a test for criminal intent, newly created offences such as terrorism, organized crime, mob lynching, and negligent acts adds novel dimension. Since this opportunity was given to me by the Bar Council of India, particularly the chairman, my friends, all bar councillors of Bihar are here. This privilege I deserve for the simple reason that I am chairman of Bar Council of India here. Yes, from Bihar. Thanking you all that you have patiently heard me. Jai Hind, Jai Bharat.
Thank you, Mr. Ramakant Sharma. You have really flagged some of the important issues of concern about constitutional protections. Then you referred to the technology, and with reference to that, I think you were referring to the IT Act of 2000, where we have some provisions with regard to the cybercrime, the
need for rights of the accused, societies, trial justice is talking about in this case. But the point is there are various elements in our criminal justice system, and all of those must be addressed in a coherent manner. Are we clear whether our system is citizen-centric, victim or accused, or is it state-centric? From birth to death, the criminal justice system I'm sorry to say this, a liberty-oriented court, and another court which is more, let us say, conservative, and the individual doesn't know why am I out and why is the other. And the same thing for the victim. The victim feels, why is an accused out in my case and not in others? And that takes into the issue of pre-trial detention, but that's another topic meant for a whole day conference, not for 1 day, not for a few minutes. The third thing I want to talk about is sentencing. Are we clear in our minds whether it's deterrence, retribution or reformation as Seema-san spoke? Or should we not be clear? There needs to be much thought on these areas for a society which talks about an evolving society which is looking at the 21st century as a leader of the world. For that society, I believe rehabilitation, reformation is very important. Our judges talk of it all the time, but does it really work out that way is the question to be asked. And in all of this, I say to you, there is also time, as the Attorney General has mentioned to me in the past, for a National Institute of Criminal Justice Administration where we talk and debate these issues, because it is time for us to bring this debate to the fore. These four are very important, but we must make it an institutionalized mechanism where we have greater understanding. In the passing, I'm going to just mention one thing, being a member of NALSA. So you spoke about the defense advocates that have been brought in, Mr. Seema. We brought in, I'm a member of NALSA, we brought in as the pilot project in 17 districts. Now we are implementing all over the country, and you will see a change, at least in terms of providing legal aid to individuals. Now the second thing I want to speak about very briefly is, we have data from the NCRB, but it is coherent. Is it coherent? In court time, we talked about people in prison, So we had data which the Honorable Supreme Court used of 2018. But that talked about the people in jail at one point of time, not the people going in and out. Not 5 lakh people are not the people in jail. They may be at one point of time, but there's a lot more going in and out. And therefore we need to see how long are people spending and in how many crimes. And it's so wide. So while we have data today, and there is, the NCRB has done a good job, especially in this 2021 report, we need data which has greater dimensions for us to have a greater understanding of the operations of the criminal justice system. We need to have legal audit of our legislation. Does the legislation brought in today work out 5 years, 10 years later? How many convictions, how many sentences are there from the rule of evidence of procedure? And if so, should we not be requesting the legislature to look at it? Thirdly, we live in a world of technology. Technology and the interface of law and criminal law is something which is very important. We have seen trials being conducted in this country also, now with the use of technology. But there is another aspect of technology, and that's the changing facets of cybercrime. Social media, call it free speech, call it, I won't call it hate speech, I'll call it hostile speech. Do I have the privilege not to be defamed? And if so, what's my remedy? These are matters which must engage the criminal justice system, because the criminal law remedy is sometimes the preferred remedy, and as a practitioner of criminal law, I'm not complaining. There are concerns of what the social norms and attitudes, how we perceive, how society has changed. There is India, as we call it, and then there is Bharat. But Bharat is evolving faster than India. India may still be stuck. The urban society may still be stuck in a certain place, but Bharat is evolving. And how is it evolving? When you see every child with access to a digital phone, to a hand phone, and see the kind of material he or she can access or propound or see or send out, it is an alarming situation. I'm not saying there's a need for great regulation, but there's a need for understanding how our society is changing. We talk about reform, but one of the things we must talk about reform also is the execution of our criminal justice system. Judges are supposed to be and act as umpires in ensuring that there's a fair trial in our adversarial system. But what are we doing about scientific investigations? As late as last week, I have had occasion to assist the Honorable Supreme Court in a death penalty case where 3 people were acquitted. So I asked myself this question: can I advise them today? It was a legal aid matter to Project 39A. Can I ask them today to go back and claim compensation? I can't. They've been on death penalty, 2 of them for more than a decade. Do we have a remedy to compensate those who are unjustly put to prison, whose liberty is lost, whose reputation is lost? The answer clearly is no. There is a law commission report which made some recommendations, but nothing. And I would really say that this is time for us to look at scientifically oriented investigations. Technology must be used as a tool to ensure that the innocent are not prosecuted. I'm not talking about punishment, they are not even prosecuted ideally. 2 more things and I will wind up. The way forward is use technology in investigations, in the way we carry out our criminal law processes, it will help careers. Use technology in the way we resolve people. For example, bail. Why can't we have electronic collars so a person can be released, but the monitor? Today your mobile phone is the biggest monitoring you have. The electronic collar will work like that. If we can use it for trucks, I don't know if you know, every commercial truck has 2 chips so that anywhere in the country it can never get lost. It is embedded. Why can't we use that if you want to release people? Why flood our jails? It may be a restraint on liberty, but it's better than being in jail. So the way forward is technology, but we must also keep looking at it when we look at things like facial recognition, linguistic translation, voice recognition. We must also be sensitive to the privacy issues of an individual and the biases that may enter technology. After all, AI is not without biases, it will have the biases of the individual. So bias reduced technology is what we should aim to ensure fairness in our criminal justice system. There is of course hope because as you may be aware, the Government of India is recently looking at poor prisoners. The Ministry of Home Affairs, the DOG has done extensive work trying to implement all these programs, which is very, very important for our criminal justice system. I will just leave you with one thought. We are at an important stage in our social development where we are transitioning, and we may even be transitioning to new laws. The new laws have a lot of interesting things, but we will have to see if we bring in harsher laws, reverse burdens, are we doing justice to our society? Are we not diluting the presumption of innocence which has been a hallmark of Article 21 of our criminal justice system? So any law that must come must be sensitive to the, I would call it not the couple, because the penal couple is the victim of the accused, but the penal trio, society, the accused and the victim. Thank you very much.
Thank you, Mr. Mukar, who's commenced with the lack of coherence in criminal justice system, and very aptly you explained the inconsistencies sometimes in judicial approach, also the requirement of rehabilitation, reformation, legal audit, technology, are these very important issues, and what kind of and to what extent the technology can be used for expediting the criminal justice system. Then changing laws and of course compensatory scheme are very important issues. We have discussed senior criminal lawyer from the country, confined to Bombay High Court, where frequently he is in Supreme Court also. We request him to enlighten us on some of the issues.
Sorry, Justice Suryakant, Justice Mishra, the learned attorney, Justice Suryakant, Justice Mishra, the Honorable Attorney General, educationists, colleagues, and I think most importantly the students of law. Am I sort of audible at the back? Because I think a lot of this is more about the youngsters today who are sitting in this crowd than for me, who probably understands very little about what I'm going to talk about. It's always a pleasure to explore emerging areas of the law with the legal fraternity, the participants in the justice delivery process, and the students of the law. And I thank the Bar Council of India for this opportunity. The landscape of criminal law is vast, complex, and changing very fast. And I must tell you that what you've seen today is barely the tip of the iceberg, and therefore it's next to impossible for us to really undertake any kind of a proper discussion or debate on a subject as vast and critical as this. So I'm only going to pick up a few limited aspects of it. Society is evolving at the speed of the currents in the internet ocean. In this 21st century, transformation is occurring every decade. The first decade was the growth of computers and computing after the Y2K fears. The second decade was the explosion of the internet. And now this third decade, we are wondering whether the advent of ChatGPT and AI is bringing the slow death of the search engines which was brought about the growth of the internet. And simultaneously in this same decade is the growth of AI and fake news. So one wonders whether at this space of technological revolution, and some of my colleagues have touched upon technological revolutions, in the space of this technological revolution, the next decade will see ChatGPT and internet as we know it being taken over by artificial intelligence and more importantly non-truth. So no conversation or debate on any facet of the law can now not recognize these cataclysmic changes. And criminal law is no exception. In fact, the role of criminal law is crucial for the orderly behavior of society. Justice Suryakant adverted to that in his opening. Truth is supposed to be the journey in a criminal case. And in this context, the landscape is changing and is changing at an extraordinary pace. The jungle is vast and it's too complicated to pass through. and all of which lie in the crucible of the judiciary to judge and enforce. We now live in a world of audacious crimes, audacious surveillance, and audacious technologies which not only help commit crimes but provide investigative tools. All these activities are premised upon the access to big data. So if some of you have read Yuval Harari's book, and if you follow him, his recent book, which is 21 Lessons for the 21st Century, portrays a fascinating perspective of the future of human society. At times a bit too frightening, but that's a conversation for another day. But he makes a telling observation, and I quote, "In ancient times, land was the most important asset in the world, and politics was a struggle to control land. In the modern era, machines and factories become more important than land, and political struggles focused on controlling these vital means of production. In the 21st century, however, data will eclipse both land and machinery, and the political struggle will be to control the flow of data. This is the legal challenge we must debate in the dispensation of justice. In fact, today data is the oxygen for criminals and investigative agencies alike. The game of this century is the control of data, and he who controls data will control the people. Wars, metaphorically, will be fought over this control. And I'm not here to make any doomsday claims about how AI and ChatGPT are the end of free-thinking lawyers and the process of judging. Instead, like all tools, I firmly believe that the latest developments and advancements in technology should be something we work with rather than against. However, in order to do so, it's important to understand how the new age technologies affect criminal law. The three areas that I intend to touch upon are data creation, that is a crime, data collection, that is surveillance, and data crunching, which is the sanctity of evidence. So data creation. Crimes in the physical world are being committed in the virtual world. We have seen the growth of cyber terrorism, cyber extortion, cyber theft, cyber fraud, etc. Some of you may recollect the robbery of the Central Bank of Bangladesh a few years ago. It was a remote robbery of nearly about $100 billion by anonymous robbers sitting somewhere far away from Bangladesh and transporting the monies in seconds to places outside of Bangladesh. All this was done through a hack into their SWIFT money transfer system. Just as digital world has spawned the cyber crimes of the early 2000s, the latest developments in AI are being used to harness the data in the digital space to create and commit audacious crimes. The digital space has allowed the anonymization of criminals and hence increases the challenges in investigations. So some examples of these audacious crimes that we've seen recently. The Twitter Bitcoin scam of July 2020, and so maybe the youngsters have read about it, I read about it recently, where hackers compromised high-profile Twitter accounts of persons like Barack Obama, Elon Musk, and Bill Gates using artificial intelligence to promote cryptocurrency. A very recent example of AI was AI-generated deep fake vocals of a prominent singer by the name Drake. He's a famous rap singer in the world, which song was nominated for the best rap song and song of the year at the Grammy Awards this year. But Drake said he never lent his voice to that song. In India, we have seen Mr. Amitabh Bachchan and Mr. Anil Kapoor obtaining John Doe injunctions from the Delhi High Court, prohibiting persons from faking their voices with deepfake technology. And some of the audacious use of technology are when a politician uses this technology for delivering a speech in a language he could not converse in. Or in the Bhima Koregaon case, where it is alleged that incriminating evidence was remotely introduced in the computer system of some of the accused. It is becoming tougher and tougher to identify certain types of crimes that are perpetrated using AI. For example, a very novel event which happened recently was a woman in Arizona was convinced that her daughter had been kidnapped for $1 million ransom due to the criminals using deep faking technology and faking the daughter's voice. The possibilities are endless. So in the same way that we saw a rise in softwares that could detect if something was generated by ChatGPT, companies are working on programs that can identify deepfakes and other false and fake information which is invading the system much more accurately than the human can. This takes me to the second aspect, which is data collection or surveillance. The world is currently phygital, that is both physical and digital. But as India becomes a developed nation in its walk to 100 years, it may turn entirely digital. While having a positive implication for innovation, commerce, governance and convenience, these developments throw up a very important question in respect to our newly minted fundamental right to privacy under the Puttaswamy case and the need for judicial oversight in the data collection process. You will all be familiar with George Orwell, whose book 1984 was written in a post-industrial revolution, post-World War II, pre-internet revolution, when he said televisions will watch people and not the other way around. Computers, rockets to outer space and satellites circling the earth were dreams, and the internet and artificial intelligence were possibly more comic book stories. He lived in a physical and analog world and warned about an autocratic government watching over every private moment of a citizen's life. He worried about the adage that every man's home is his castle and fortress, a proposition settled in Semayan's case in 1684. In 1763, in Huckle versus Money it was held, to enter a man's house by virtue of a nameless warrant in order to procure evidence is worse than the Spanish Inquisition. This case held that a magistrate cannot exercise arbitrary powers which violated the Magna Carta. Across the Atlantic Ocean, the US Constitution 250 years ago guaranteed the same rights through the Fourth Amendment. The right of the people to be secure in their persons, houses, papers and effects against unreasonable searches and seizures. These were constitutionally protected rights. The right against non-interference in one's private life and the right against non-surveillance. But in India, these were not part of our constitution when and as it was framed. Though there was an attempt to include it as a fundamental right, the same was nixed. But the Orwellian world of today is about our castle and fortress having evolved to include our computers, mobile phone, social media accounts, and soon, as the youngsters will know in this crowd, our avatar and home in the meta space. Communication is through text messages, WhatsApps, images, gestures, emoticons, memes and the like. The most private thoughts of the young generation and emotions are being instantly shared through these mediums in the belief of complete privacy. Memories are being downloaded on memory cards. Already the world has mass surveillance programs with AI-linked data analytics. The identity of a person is linked to his face, his retina, his voice, handwriting, fingerprints and DNA. But today's technology keeps all of this on a server. Your smartphones carry your fingerprint or your face ID. India's own mass surveillance programs are manifold. We have heard stories of illegal surveillance from governments, Saudi government alleging surveilling Jeff Bezos' phone by hacking his phone, or the recent scandal around the use of Pegasus spyware by certain governments including Netherlands, Belgium and Germany, or illegal tapping of the phones. Consider that nearly 100% of the Indian adult population has an Aadhaar card, and over 70% of the country has access to smartphones. Imagine that virtually all private actions of the entire population are being captured on real-time basis, forming a large data set that investigating authorities can rely on as part of their process. Surveillance gives a location and nature of evidence in an investigation. This can trigger a search and seizure action to collect and recover the evidence. This power is undoubtedly inherent to a successful investigation. Data which previously remained in my head or in my body is now available across the internet. Information that was private to an individual and more importantly privately held by that individual is now held on a server owned by someone else. If access to such server can be made available, can it be said that the individual has consented to the private information being collected by investigating agencies? Should every individual be forced to think twice before sharing their lives with the internet? Whilst the debate on collection of evidence through the search and seizure power started in the Constituent Assembly in 1949-50, the debate in the Supreme Court began in 1954. In 1954, 8 judges and again in 1962, 7 judges in Sharma and Kharak Singh's case considered the issues of search and seizure, surveillance, privacy, criminal investigations and fundamental rights. While negating the elevation of the right to privacy to a fundamental right, it reaffirmed the overriding state power of search and seizure for protection of social security and surveillance. But in 1975, the Matthew, Krishnaiyer and Goswami court once again examined the issue in the context of surveillance through domiciliary visits and started a journey of leaning in favor of privacy being a facet of fundamental rights, a topic that was also just briefly touched upon. However, the watershed moment in the Indian constitutional history was in 2017, when 9 judges of the Supreme Court in Puttaswamy held that privacy rights are part of Article 21 of the Constitution and elevated it to a fundamental right. Consequently, privacy, the new fundamental right, can be invaded only in accordance with the procedure established by law, and the law must satisfy the tests not only of Maneka Gandhi's case, but the Supreme Court has established the proportionality and legitimacy test. Following this, in 2018, the Aadhaar judgment, 5 judges struck down some of the provisions of the Act which permitted the use of Aadhaar information for the purpose of investigation. So criminal investigations and criminal justice delivery process will have to bear in mind these new tenets in this new world order of continuing involuntary surveillance. This takes me to data crunching and the sanctity of evidence. With the alarming rise of surveillance tools, what are the checks and balances that must come to bear in the course of appreciation of any information gathered by such surveillance? I've already mentioned giving a few illustrations of the complexities in investigations which arise on account of these new technologies. While there are physical world parallels, the digital nature of these actions forces us to rethink the sanctity of digital evidence. Considering the varying complexity at both ends of the justice system, which is in the use and the misuse of technology, that is deep surveillance into one's personal private matters and also the complex crimes that occur using the technology, the question is, how does the judicial process assess the evidence gathered pursuant to such almost limitless surveillance? And these are only some of my personal thoughts on the subject to provoke a debate and a discussion for which I think we are here gathered. Firstly, is the doctrine of evidentiary exclusion principle. In the post-Puttaswamy era, the question is, do we bury or modify the ghost of the Puranmal doctrine? The Puranmal doctrine, which was an income tax case, provides that evidence recovered from an illegal search is admissible but is subject to a greater scrutiny. This was a tax case, but the principle was extended to all types of criminal cases. Is it now time to follow the dictum of Baldev, which in 1999 disregarded Puranmal doctrine in the context of personal search under Section 50 of the Narcotics Act? This was an invasion of personal or body privacy. In Baldev, 5 judges adopted the fruit of the poisonous tree doctrine. The court observed, and I quote, "Prosecution cannot be permitted to take advantage of its own wrong. Conducting a fair trial for those who are accused of a criminal offense is a cornerstone of our democratic society." So while considering the aspect of fair trial, the nature of the evidence obtained and the nature of the safeguard violated are both relevant factors. We must also note the caution of Justice Ramasubramaniam in the famous Arjun Pandit Rao case in 2020 while dealing with Section 65B of the Evidence Act, which deals with digital evidence. He said a photo taken with an analog camera can remain a single object, but a photo taken with a digital camera is stored in zeros and ones and hence can be manipulated. So analog maintains the integrity of evidence, whereas digital has the capability of destroying the integrity of evidence. Our 65B needs some reconsideration. Technologically advanced nations have experimented with special rules of evidence and have, after realizing the problems, have reverted back to the traditional rules of proof and admissibility. Second thought is the requirement of enhanced form of consent. To the point I briefly mentioned earlier, the elements of consent underlying data seized needs to satisfy a higher standard of admissibility. Consent in accessing electronic data, consent to undergo polygraph tests, consent to undergo narco analysis, consent to provide voice sample, or consent to provide biometrics. All the evidence collected through means of this consent tend to fall in the self-incriminatory doctrine bucket and risk being violative of Article 20, Sub-Article 3. How is this consent obtained and recorded? If the evidence is obtained through means of involuntary collection of this personal information without consent, how will courts view this evidence in the context of invasion of privacy? Will every investigation fall within the state interest exception? Every time you visit a website and accept a cookie, should that be deemed consent for an investigative authority to override your right to privacy. Thirdly is the chain of custody rule. The integrity of evidence such as voice and biometrics at the risk of cloning, documents at the risk of duplication, modification and fabrication, images are at the risk of being modified or created, and digital footprints or fingerprints or footprints are capable of being stolen or erased. Identities are at the risk of theft. Consequently, the chain of custody of evidence collected must be impeccable. So friends, as we stand at the crossroads of technological advancement and legal ethics, let us navigate this path in an internationally collaborative manner with prudence, ensuring that the promise of digital technology and AI in the criminal justice system is realized while upholding justice, fairness, and individual rights. Thank you very much, my friends.
Thank you, Mr. Desai. You have really given a very deep insight of it's not only the cyber crime, but all the related, the technology-based issues that are arising and which are the, not future, rather the current challenges we have started facing. And maybe the deficiencies in the IT Act, and maybe that we need to have some more robust legal mechanism for data protection, etc. And all these issues, of course, right from hacking to illegal tapping and all these very serious issues of whether it's cryptocurrency or these are very important gray areas where the difficulty is that these are the offences which, as you rightly pointed out, Bangladesh instance, don't have any geographical boundaries and can be committed from any part of the world. So how to deal with them, probably you need to have a global consensus-based policy to which all the stakeholder countries need to sit together and evolve it. All these issues are very, very interesting issues. Thank you very much. We now request Mr. Dhyan Krishnan to say a few words, and then we throw open to the audience.
Honorable Justice Suryakant, Honorable Justice Mishra, my friends on the dais, the Attorney General for India, ladies and gentlemen. I want to concentrate a little bit on and take forward what Mr. Desai dealt with and deal with the issues which really confront us in cross-border crime. But before that, I was very interested by the opening remark of Justice Suryakant, who started by asking us the question as how criminal law evolved. And the changing nature of criminal law, actually jurisprudentially, goes back to that constant tussle between society trying to keep people within a certain set of norms, and on the other hand, an individual for personal gain or otherwise wanting to break out of these norms. The best theory, which is sociological, which we use in jurisprudence, is clearly the theory of Emil Durkheim, who used the functionalist theory to say that social regulation, social integration, and social change together force society to evolve and meet the challenges by an individual to break out of these societal norms. Now, one area which I also happen to practice a fair amount is an area of extradition which faces these changes on a daily basis. The changes really relate to the issues of technological crime. Today, where we were talking about hacking, we are talking about cryptocurrency, and the requirement of serious international legal changes. Take, for instance, a common internet crime. On one hand, you have the domain host, which is based in one country, the domain registrar, who is based in another country, the criminal in a third country, and the victim in the fourth country. Now, what is the fundamental challenge that we face in such cases? Either appearing for the government in an extradition or appearing against the government defending an extradition. The challenge is a challenge of jurisdiction. And today in international law, there is no unanimity in jurisdiction. You have the principles of subjective territorial jurisdiction, which is a jurisdiction which is conferred on the country where the criminal conceives or commits the crime. You have the principle of objective territorial jurisdiction, which is the point where the victim faces the crime. You have the principle of nationality, which is a part of the Indian Penal Code in Section 4.1, which says that India will exercise jurisdiction over all its citizens wherever the crime is committed. And the decision and the principle of passive personality, or it's the old Roman principle, which America uses in certain statutes to say wherever my citizen is, I will exercise jurisdiction. But the conundrum is this: where is the recognition of a hierarchy of jurisdictions? And this becomes critical when you deal with international crime, because each country asserts jurisdiction in its own way. And therefore, there is an absolute requirement to come to a global consensus in order to achieve the principle of objective territoriality, that is a victim-centered jurisdiction by way either of international treaty or by way of customary international law. Of course, customary international law will take its own time, but by way of treaty. And our experiences in the post-9/11 era of international crime and cooperation have shown that treaty works very well. Take the example of the MLATs. Today, every Indian investigating agency uses the MLAT. Earlier, we used to get information under the interrogatory regime under 166A of the Code of Criminal Procedure. And all of us know, who are on this dais, that most of that material never came, and many times when it came, the trials were over. But today, because of the mutual legal assistance treaties, investigators are able to get material real time. And a great example of international cooperation. But we need a similar regime as far as international jurisdiction is concerned. Now, without doubt, today and the events of the recent past have shown that India is diplomatically powerful. This was not a situation over the years when we faced various reverses in extradition. But this requires both diplomatic as well executive and legislative changes. Take the Indian Extradition Act and compare it with the UK Act of 2003. The UK Act of 2003 has a schedule which is called Category 1 and Category 2 in Part A countries, where if you are notified on reciprocity, there is no requirement of a prima facie case analysis. Today, most of our extraditions are stuck because of long procedures. In the United Kingdom, for example, of course it happens in other countries like Spain, etc., where because of the lack of this reciprocity, courts go into an entire analysis of whether a prima facie case is made out. Secondly, executive action is also required. The Indian Extradition Act is actually, post its 1993 amendment, an extremely forward-thinking act. It provides in Part 3 of read with Section 12 for the central government to notify similarly such countries. But if you look at that schedule, it is laughable. The schedules the countries we have notified are Turkey, Turkmenistan, Azerbaijan. I don't believe, in my limited experience in extradition, that any of our fugitives go to such countries. And the countries where our fugitives run to are countries which are not notified on reciprocity. A classic example of why we need to act in furtherance of existing legislative framework and international understanding, so that cross-border crimes, which is really the evolving nature of crime, is quickly dealt with. Take another issue which arises in extraditions, the issue of jail conditions, human rights record of a country. It's not that the countries where the fugitive is living have very great human rights records. Therefore, these again become a whole loop by which the fugitive continues to remain there. But a good example is the example followed by the United States by using the principle of non-inquiry. The famous United States judgment in Neely versus Henkel way back in 1901 said this: but such citizenship does not give him an immunity to commit crime in other countries, nor entitle him to demand of right a trial in any other mode than what was allowed to its own people by the country whose laws he has violated and from whose justice he has fled. This is again a requirement by way of international consensus that all countries who have democratically elected governments, a robust judiciary, and good investigating agencies must adopt the principle of non-inquiry. So the moment the country says, yes, he has committed a crime in my country, the fugitive must be returned. The last point which I want to raise for your consideration is the problem of enforcement of orders. And this is in the domestic jurisdiction. Very recently, without taking names, I was doing a case relating to a large corporation in the Delhi High Court, whose entire data was taken away by a hacker, who then sought the return of the data for ransom on the basis of payment in cryptocurrency. This is quite common. So both in a civil suit, we got an injunction and a blocking order. In a criminal case, we got an order under Section 69 capital A of the Information Technology Act. But at some level, both these orders were of no use. The rogue websites never ever come to our jurisdiction. The maximum you can do is the internet service provider would block that website. But as all of you know here, all you require is a VPN or a proxy subscription, where a VPN proxy will take you to that same website. The point I'm making is, technology and criminals have gone far ahead of law. The solutions don't rest only with lawyers, judges, and investigators. The solutions actually also rest with technology and technocrats. But the time has come for us to understand that we need to think globally. Think globally in terms of how we frame our laws, how we do our investigations, and how we need to achieve global cooperation. Thank you very much for your time.
Thank you, Mr. Krishnan. That technology and criminals have gone far ahead. The issues of cross-border criminality, extradition of the suspects and all these issues which we face because of lack of unanimity among the different jurisdictions, these are very crucial issues, and he may be right in pointing out that there are several white-collar criminals or the other offenders who are taking undue advantage of this kind of situation. We hope that the stakeholders will definitely address all these issues and will take some effective measures. Ladies and gentlemen, there are time constraints, but as I promised from the very beginning, we would like to have some brief questions from your side, and the panelists will try to respond. Yes, please, one by one. Do we have any? All right, you.
You can come up here. Sir?
It will take time. Then.
They need a mic. We have another mic. So we'll just prosecution will come up.
I am Sharik Ahmed, the practicing advocate in Supreme Court. Sir, Honorable Chairperson, sir, my query is that in law schools we were taught that the moment FIR is lodged, the criminal law is set in motion. But in few of the states, and my learned senior colleague Mr. Luthra would agree, that in some of the states, the moment FIR is lodged, bulldozer is also set in motion. are we heading towards a legal regime where bulldozer 2 would be recognized as the most potent way of administering and imparting justice? Thank you.
May I request that unless either with case-specific discussion, that may not be possible with the time constraints. Let's discuss the general principles and the broader legal issues. With regard to reformations and whatever be the changing the landscape of the criminal law, let's confine to that subject. Maybe because people can have different kind of views and issues depending upon the facts and circumstances. Let's have a general principle-based discussion. Yes, please. Those who want to ask questions, I think you can come here and one by one then.
Good morning, all the esteemed personalities present here. I am Amalna from ILC, Goa. And my question is, the Criminal Procedure Identification Act of the year 2022 allows the storage of biological samples for over a 75 years period of time. The biological samples such as DNA can be used to procure the whole family lineage. So how the right of privacy under Article 21 of the accused and the right of the victim to have a detailed investigation can be balanced out, as according to the Act, the denial of giving the samples is also charged with a criminal consequence. Thank you.
The young lady has touched upon an issue that really needs to be debated. Undoubtedly, the rights of privacy will have to be balanced with the needs of an investigative agency, and it will be fact-specific, but I do hope that as the matters land up, because we struggle with, as a practicing lawyer, I think we struggle with these kind of issues, and I've raised some of these problems for consideration and debate as to how in the Kuppuswamy regime, we will have to balance out this very issue about DNA samples of private family members and how will you balance it and admit it into evidence. I probably have a more conservative view, having spent my years as a defense lawyer, but I must recognize that there is a very serious counterpoint that courts have to take into account, and in many cases it will evolve based upon a set of facts. I think the broad philosophy will have to be balanced in this context, but I think that's where we'll have to do it. I don't think we have a direct answer to that.
Thank you. Thank you. Yes, please.
Good afternoon, sir. Sir, I am asking just about the law adopted by the police as well as the investigation as the lower court. I am practicing is High Court. Sir, in the judgment of Arlesh Kumar versus State of Bihar and the Sundar Kumar versus CBI, the mandatory provisions and mandatory directions were given by the High Court, Supreme Court, but the police just to provide themselves from the orbit of these particular judgments, they just write in the FIR and in the remand paper section 467, 468, it is in the orbit of the imprisonment. But in most of the cases, there are no evidence regarding 467, 468, in the 90% cases, the people are lying in the jails, and these are police as well as the judicial magistrates who are not caring about these judgments in the directions given by the Supreme Courts. They are not listening directions about these particular line of judgments. These judgments are the ornaments of our constitution, and we have to wear these ornaments with respect. Thank you so much.
So that's straight away. At the stage of remand or arrest, you are entitled to say the other offences which are within 7 years are not retracted, and 41 ought to be complied with. Until there is a specific para on this, you may want to refer to that.
Thank you. Yes, with kind permission of the chair, if chair permits me, I want to read indicate two interesting amendments in ITC. If chair permits me, I want to read that only. The proposed amendment in section 2 in IPC.
Are you discussing the proposed
As per my view, it is going to change entire justice with delivery system, criminal justice delivery system in India.
Please appreciate if you have some suggestions for the proposed new criminal laws, you give your suggestions.
No, I'm not giving any new suggestion, but I want that this proposed amendment must be discussed among this legal fraternity. That's something.
You please send it, we request you to send a detailed mail to BCI. If you can give your suggestions, because
section 255 says, whoever being a public servant corruptly or maliciously makes or pronounces in any stage of the judicial proceeding any report, order, verdict or decision which he knows contrary to law shall be punished with imprisonment.
These are the suggestions you can give. Please don't ask for keeping things and you will give us suggestions.
Our law judiciary will not be under threat. After that,
what we will request is that because of the time question, all the audience, we request you please send your suggestions and your questions to BCI through mail, and we will. Yes. Lani Attorney General wants to say something. He's most welcome.
So please.
So,
it's neither questions nor answers. I'm here only to listen and take stock of the concerns that have been raised. I've been closely watching some of the issues that have been arising in the past 1 year. What occurs to me is that we need to structure our interactions. It becomes very ad hoc when we meet occasionally like this. We're not able to take stock of at a very deeper level. So a couple of structural interventions. My learned friend Siddharth Uttara had been talking about it, but probably I'll be able to persuade the government through conversations occurring through these conferences that we need to have a National Institute of Criminal Justice Administration. And I want all the vice chancellors here and the law school heads and the academicians to take part in this initiative, because if you're talking about balancing rights, it can't be done only, I think, in a court proceeding. It has to be probably guided by a whole set of guidelines and principles and working arrangements. The second is, I'm also contemplating to have a standing conference of advocate generals and the senior advocates from different parts of the various parts of the country to keep meeting as often as possible to take stock of what's happening in the criminal justice system and be able to produce voluntary reports to the government. Law Commission will do its job. But this kind of an initiative I thought was also equally important. So I take this opportunity of inviting all the like-minded persons in the field of criminal justice and an indirect appeal to all the advocate generals to take part in the very important initiative. Because recently when I was appearing for a criminal matter, when question of narco analysis, whether I can refuse to be subject to an invasive investigative procedure like this, many questions came to my mind. Probably one point of time in the Law Commission, I was thinking that many of the legislation require principles of interpretations part of the legislations, which may guide the courts. Then I thought it's a little naive suggestion, because very often the courts are confronted with what you may say the principles, DK Basu for that matter. But courts every day are called upon to revisit DK Basu. So perhaps something fundamental can be done to make all the three legislatures which have come. Probably we have some kind of a national criminal justice guidelines procedures, which will inform sentencing procedures, which will inform interpretation procedures, and so on and so forth. I am extremely grateful to many of the very insightful presentation today, First Dayan Kishan, and the global development and how we take stock of the global situation. I am thankful so much.
Thank you, the Attorney General of India, that for your
assurance on the two major issues, and I think the initiative of talking to all senior advocates from different parts of the country will be a very welcome step. That will really lead to a coordinated effort in the perpetual kind of reformatory steps which we are required to take from time to time. Thank you very much for that.
Thanks. What of sir? It is my turn. Good afternoon to everybody on the behalf of Aguilas of the Dayas. It gives me immense pleasure to pay a vote of thanks on this second day International Lawyers Conference on behalf of the Bar Council of India. I extend our gratitude to the Honorable Justice Suryakant, Judge of Supreme Court of India, today's chairman of this function, Honorable Justice Prashant Kumar Mishra, Judge Supreme Court of India, and former High Court Judge of our state, Andhra Pradesh, leading the session a day in a very fruitful way. I would also like to express our gratitude to our esteemed speakers, Mr. R.S. Seema, Mr. Ramakant, Chairman Bar Council of Bihar, Mr. Amit Desai, Senior Advocate, Siddharth Luthra, Dayan Krishnan, Senior Advocate of Supreme Court, who have shared their insights of the experiences of contributing to our collective understanding of evolving legal and scape of in global scale. I thank the delegates of the participants who became the best part of this conference. My special best of blessings to the law students who are the future hope of the Indian legal system as we live here today. Let us carry with us a knowledge. Concluding some aspirations of the grain from these insightful lectures. Together, we can continue to build bridges across borders and promote the values of justice, ethics, and professionalism. Let us remember the strength of the law is its fairness and the power of justice is its equality. Thank you, one and all. Thank you very much for it.
Thank you very much. Thank you to everyone.